Good morning, everyone, and thank you for joining us for the Medical Board of California Interim Panel B meeting. Pursuant to the provisions of SB 189, this meeting is being conducted via WebEx. If you're having difficulty hearing the audio of this meeting, it could be because the device you're connecting with has bandwidth limitations. If you do have difficulty hearing the audio of this meeting using your device, please click the ellipsis button at the bottom of the WebEx application or the audio and video menu option at the top of the WebEx application, and then select Switch Audio. You will see an option to call in and will be provided with a telephone number, access code, and attendee ID that can be used to connect to the meeting audio via phone. Using the information provided, it will automatically disconnect your device's audio and connect your phone to the name you joined the meeting with. By using this method, if you're having audio problems with your device, it will allow you to still participate and hear the audio of the board meeting. Please see the instructions on how to connect on the last page of the meeting agenda for step-by-step WebEx instructions, including screenshots. Thank you, Dr. Thorpe. You can now start the meeting.
Thank you, Sean. Well, welcome, everyone. Thanks very much for taking the time out of everyone's busy day. I know that everyone has lots of things going on today, and so I appreciate your willingness to be here to help us decide this matter. And thanks, Judge Larson, for your being willing to be with us today. I don't really have. I think you all have had the chance to review the materials for today's deliberation, and I don't see anything we need to do other than to just turn it over to Judge Larson for the hearing.
Can I take the roll? Should I?
Oh,
the
no,
roll?
no, we can't take the roll. Yeah, please. Thanks, Carrie. Thanks.
Thank you, Dr. Thorpe. Dr. Thorpe,
Aye.
Mr. Rooks,
Here.
Dr. Hielzer,
Here.
Ms. Lawson,
Here.
Dr. Mahmood, absent. Thank you. We have a quorum.
Thanks, Carrie. Okay, Judge Larson, now it's you.
All right. As soon as our court reporter tells me she is ready, we will go on the record.
Thank you, Your Honor. I just want to make sure I can see everybody, and right now I'm not able to see everyone. So when you just give me a moment, Your Honor.
Of course.
Thank
So
you.
there's some folks we can see. There's some folks that we may not be able to see because they may not be on camera.
Linda, if you see that little layout button, make sure you're on the grid layout, and that way you should be able to see.
Okay, Sean, I don't see that. Where is that?
Upper in the kind of upper right to middle-ish of the screen next to the participants window, that if you float your mouse up there, a little layout button will appear.
Got it. Thank you so much.
Make sure that one's on grid. That's usually the option for best seeing everyone.
Before we go on the record, I also want to just confirm, I've seen some names. Miss Angus, are you the DAG for this matter this morning? Or it's up?
I am not. I am actually counsel for the board, and I do not intend to participate in this part of the hearing.
Right. I'm not seeing who's the Deputy Attorney General? Oh, Mr. McKinnon, there you are. Your name was not. Good morning. Your name was not popping up. And then counsel for respondent, help me with your last name. I want to make sure I say it correctly.
It's pronounced Riffit, Your Honor. And for the court reporter's benefit, my video will not be working today, but hopefully she can hear me.
All right, Mr. Riffit, Mr. McKinnon, we're all here then. And then I see Dr. Smith as well. Wonderful. All right, Ms. Temple, just please let me know when you are ready.
I'm ready, Your Honor. Thank you.
All right, on the record. Good morning. We are on the record before the Medical Board of California, Panel B, in the matter of the first amended accusation against David James Smith, MD. This is Medical Board case number 800-2015-013651, OAH case number 2018-080617. Today is July 22nd, 2022. It is approximately 11:05 a.m. This is the date, time, and place set for the oral argument and the notice of hearing for oral argument. This matter is being heard through WebEx. My name is Marcy Larson. I'm an administrative law judge with the Office of Administrative Hearings. I've been assigned to preside over this matter with Panel B. Prior to going on the record, the board members of panel B identified themselves and a quorum was established. May I please take the appearance of the Deputy Attorney General?
Good morning, Your Honor. Deputy Attorney General Joe McKenna on behalf of complainant.
And counsel for respondent.
Good morning, Your Honor. Matt Riffett, RIFAT, for the respondent, David Smith, who's in attendance.
All right. The board in this matter has issued an oral argument after Superior Court decision. The board has invited particular discussion with regards to the level of discipline to be imposed for respondents' conduct involving patients B and E. The following time limitations will apply in this matter. Respondent will have 15 minutes to make an opening argument. The Deputy Attorney General will then have 15 minutes for a response. Respondent will then have 5 minutes for closing argument, and the Deputy Attorney General will have 5 minutes for closing argument. These time limits will be strictly enforced. The arguments shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. Myself or any panel member may ask a party to support the party's oral argument on the matter with a specific citation to the record. At the end of oral arguments by counsel, I will offer Dr. Smith an opportunity to address the panel with regards to the level of discipline as it relates to patients B and E. If the respondent elects to address the panel, I will place him under oath. After oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will be receiving a decision sometime in the future. Please remember that all arguments must be based on the existing record and no new evidence will be heard. And the board has already had the benefit of reading your briefs. All right, with that, Mr. Riffett, if you would please let me know when you are ready and I will begin your 15 minutes.
I am, Your Honor. Thank you very much.
All right, please begin.
Thank you. Good morning, Dr. Thorpe and members of the panel. Good morning, Your Honor. I'm Matt Riffett. I represent David Smith. There are basically 3 things that I want to outline by way of oral argument. And then, of course, as Her Honor has indicated, Dr. Smith will be speaking at the close of the proceedings. In terms of the initial matter, and I know the board is familiar with the procedural posture, but I think it's helpful in terms of the timeline to establish where we are today. As the board knows, the decision against Dr. Smith that was entered in 2020 has been set aside. That decision prescribed 7 years probation with 19 terms and was at the time based upon what was initiated in 2018 as an accusation relating to 5 patients. Remaining for the board's consideration is the evidence relative to patients B and E. The decision that the board imposed, or rather the discipline that the board imposed, provided a lengthy period of probation that is 7 years and 19 terms, all of which Dr. Smith has complied with thus far. And we are where we are at this point relative to that procedural history. The next issue I'd like to bring to the board's attention is relative to patients B and E, what we are looking at in terms of the record that was available to the board and the evidence that was adduced. We're mindful that in terms of the hearing that was had, from which the board is to make its decision, or at least based upon the board's order from which it's to make its decision, there was significant evidence both from Dr. Smith as well as from the patient's records, as well as from the board's expert relative to the issues that were presented at the time of trial, at the time of the administrative hearing. And specifically what we're looking at is Dr. Smith's practice as a pain management specialist and his treatment using multiple modalities of care for patients B and E. Central to the issues that were presented to the administrative law judge below was the question of whether Dr. Smith had comported with different guidelines and different standards that were then, remember the hearing was some time ago, 3 years ago now, that were then applicable or being discussed as applicable to the practice of pain management, and in particular, the use of morphine equivalent dosing in making clinical judgments about what was appropriate or not for particular patients. As you'll hear from Dr. Smith and is evident in the record from his testimony, the use of morphine equivalent dosing is a variety of stop sign, divesting pain management physicians of their ability to exercise independent clinical judgment, is something that was controversial at the time the accusation was filed, and it continues to be controversial. And indeed, the publicly available information, as well as the information that was presented to the administrative law judge below, shows that there was a search, if you will, for some sort of applicable standard of care on which there was universal agreement. Well, the record below just doesn't establish that there is agreement, let alone agreement during the time period that these patients were treated, which of course is the touchstone for this panel to evaluate Dr. Smith's care of these patients. There was no definitive rule or speed limit relative to morphine equivalent dosing or anything of the kind. As human beings, we are inclined to look for easy choices, for easy binary choices. So in the realm of pain management, for example, or even frankly in the application of pain management modalities in other specialties, such as internal medicine and in family practice, it's very easy to want to say, oh, well, this particular number based upon this particular calculus establishes for us a speed limit or a stop sign. And from that, we can judge what the particular provider did. So an analogy that's been used, for example, is speed limits on the highway. If a physician, or rather if a driver is in a 55 mile an hour speed zone and they're driving 56 miles an hour, we can safely sit there and say he's broken the law. But those binary equations, that binary analysis, is frequently dangerous in terms of the delivery of healthcare, particularly to patients who are not opioid naive, who have been on long-standing opioid use and treatment, to treat particularly complicated pain conditions, which include psychological overlay, in addition to physical underlying issues that the patients have that's causing them pain. Pain management, as the board knows, and this was evidence that was before the administrative law judge, is a specialty that's been around a while, but it is not a specialty that has enjoyed a long, long history that you've seen with other specialties. Indeed, when Dr. Smith started practicing some 30 years ago, the practice was fairly new, or at least the specialty was fairly new. And the notion of treating patients specifically for pain, which some have referred to as the fifth vital sign, was something that was novel in terms of a specialty. And the difficulty here in terms of evaluating Dr. Smith's care, and hence the level of discipline, is that you're evaluating a physician based upon a standard of care and a specialty that was, at the time of the trial of this case, the hearing of this case, in a state of flux. Now, at the time that the patients B and E were treated in this case, those patients and the standard of care that was applicable at the time, those patients were to be treated with the following professional judgment. The evidence establishes this. At the time the patients were treated, the question for the clinician was, treating pain as the fifth vital sign, what modalities can I apply to relieve this patient's pain while being mindful of the potential adverse sequelae or consequences health-wise for the patient? So a common thing that we all know about, or at least we all can understand, is the use of opioids causing respiratory suppression and potentially posing a health risk to the patients. Well, as Dr. Smith testified at the hearing below, he met with these patients weekly, or at least almost weekly in most instances, unless there was a missed appointment, et cetera. and was vigilant about making sure that he was monitoring the patients so that he could exercise his judgment based upon the patient's history, the patient's presentation, the patient's subjective reports of pain, and whether that subjective report of pain correlated adequately with objective measures of whether the patient's report was consistent with the way in which they presented. So, the question for the board, I think, and the ultimate touchstone is what needs to be done here relative to Dr. Smith to ensure protection of the public. And with respect to the treatment of patients B and E, I think the answer to that is that Dr. Smith has shown his conscientiousness as a provider. He's shown his hyper understanding, if I can use that phrase, of pain management, the mechanisms of action for the different medications that he provided for the patients. And even the judge herself, the administrative law judge, observed that Dr. Smith is a careful and prudent practitioner. And while she rejected his testimony as being expert, or at least rejected it relative to the testimony offered by the board's expert, she did observe that he was careful and prudent in his treatment of the patients. Now, there is a part of that the board needs to consider that I've just mentioned, which is the effect of Dr. Pope's testimony. Now, Dr. Pope is the board's expert. Dr. Pope did not have the length of history and experience that Dr. Smith had. Now, I'm not discounting Dr. Pope's credentials, and certainly if the board wants to rely on his expert testimony, it can do so. But I think the board has to measure in part what Dr. Smith was evaluating from his perspective as a longstanding pain management specialist in terms of evaluating his care and the level of potential risk for the public. Again, the mandate of the board being protection of the public. And then the third issue I'd bring to the board's attention is this, and this is an argument that I make for purposes of preserving it, mindful that the board has limited us to the record below, which is this, and I think this is stated somewhat in our briefing. Presently, as a procedural matter, there is no decision. The decision's been set aside. So what this board is now required to do is to decide essentially de novo, if you will, or anew, whether based on the record below, it thinks it's appropriate to impose discipline on Dr. Smith. Well, what the board is missing from the record is the last 2.5+ years of history. Indeed, what the board is missing is the last 4 years of history since the accusation was filed, and the last almost a decade of history since the conduct which gave rise to the accusation in the first place occurred. And I think that's troubling, because what the board is being asked to do, or at least has tasked itself with doing, is to evaluate Dr. Smith today, July 22, 2022, and determine whether discipline is appropriate at this point, this date in time, to protect the public and to ensure that Dr. Smith is a competent practitioner. Well, I'd say that's an impossible task. And that is why in our briefing, and today we'll reiterate it, the board at this point should do nothing, because the record before it is inadequate to evaluate whether Dr. Smith as a provider should be disciplined. Now, I know opposing counsel will disagree with me, at least, I mean, I'd hope he doesn't, but if he does, and I assume he will, let me suggest this to you. As the authorities make very clear, and as you all know very well, the purpose of the disciplinary system is not to punish providers. So it's not a question of, oh, well, Dr. Smith broke the speed limit back before 2018, and now we still have to write him a ticket. The question is, as Dr. Smith sits here today, is discipline appropriate against him for purposes of protection of the public and to ensure that he is a competent provider as a specialist in his field? And as I put it to you, I hope it becomes clear that the record that we presently have is inadequate, both as a substantive matter and as a matter of meaningful due process for a disciplinary order to issue. In other words, if the board issues discipline today, it will have missed years worth of evidence and years worth of material. It will also have missed the opportunity for Dr. Smith to present expert testimony concerning his care, his understanding of the standard of care, and his competency in the field. And as I said, I think I used the word surgical excision. The law, unfortunately, is not neat and tidy. It's not, we don't look at things like a cancerous growth that we can excise and look for margins and, brush our hands and say we're done. The law, unfortunately, is a bit messy. And in this case, the record, I would suggest to you, is so infected with error, that is the inability to evaluate Dr. Smith, the provider who sits before you today on July 22nd, that there is little the board, actually, there's nothing, frankly, I think the board can do. And let me give you an example. So today, the board may say, well, we should discipline him in some fashion. We don't know, or we don't have before us in the record, what training he's had, whether he's gone to Texas for a K-STAR program because PACE recused itself. We don't have whether his probation monitor has said his charts look awesome. They look great for the last 2 years. We don't have any of that. But we, the board, have to impose discipline on him. Well, if we look at the disciplinary guidelines, we may be imposing discipline on him that he's already undergone.
1 minute.
Thank you, Your Honor. So I would suggest to you that, and I understand the desire to basically freeze the record and say, we've got this evidence, there's no need to reopen it, there's no need for another accusation, no need for another trial. But I would suggest to the board that disciplining based upon the current record, without information about who the provider is that sits before you today, July 22nd, I would submit to you is not consistent with what the board is charged to do. Thank you.
All right, thank you. Mr. McKenna, tell me when you are ready, please.
Ready.
All right, you may begin.
Good morning, members of the board. Today, you're being asked to reconsider the board's decision against respondent Dr. Smith, and in particular, to reconsider the discipline that was previously imposed in light of the writ decision from the Los Angeles Superior Court. As the board is aware, the court set aside the board's August 25, 2020 decision pursuant to respondent's writ petition. Now, as outlined in my brief before the board for this hearing, the Superior Court decided that certain specific statements made by respondent's expert were erroneously excluded at the administrative hearing. And those statements related to only 3 of the 5 patients involved in this case. Now, we know that 2 of the patients B and E, the Superior Court ruled that the board was legally justified in excluding any testimony as to these patients at the hearing. The Superior Court found that there was legally sufficient evidence to impose discipline against respondent for his conduct involved with patients B and E. The Superior Court also found that the board did not abuse its discretion in the imposition of discipline against respondent. Therefore, you're being asked today to reconsider the appropriate discipline to be imposed against respondent as it relates only to these 2 patients. Now, it's important that the board not base its final decision to impose discipline on any findings involving the other 3 patients in light of the Superior Court's order in the writ. Now, in terms of reconsidering discipline, as complainant's counsel in this matter, I urge you to reimpose discipline, which should include a term of probation of 5 years, and reimpose the same terms and conditions of probation as found in the board's initial decision, with a minor alteration which is addressed in my brief, but I'll discuss a little bit later in my comments. Now, contained in my brief as are the detailed arguments for why public protection requires that respondent be placed back on probation for his conduct involving patients B and E. Now, the effective date of the decision was October 15, 2020. The decision, the Superior Court's order was issued in January 2022, roughly 15 months after he was placed on probation. And then in June of this year, the board vacated its decision pursuant to the Superior Court's writ, which is about 20 months after he was put on probation. So therefore, Respondent has served less than 2 years of probation in this case, in a case that the Superior Court described as involving serious misconduct with his patients. If the medical board does not reimpose a term of probation, this would mean that respondent would only have had his medical practice monitored for 20 months. Again, looking at the record, the seriousness of the violations across years, across these two patients, it indicates that 20 months is far too low, far too short a term to ensure public safety in this case. And to emphasize this point more, the medical board routinely imposes probation terms of 5 years involving cases with violations that are much less serious than the conduct respondent was found to have committed involving patients B and E. The sustained findings against respondent involve serious and dangerous violations with respect to his care of patient B that included multiple findings of gross negligence and a finding of excessive prescribing of controlled substances, which violation of itself contains substantial disciplinary terms. Now, with respect to the defense argument, which you just heard in this hearing, let me begin with reemphasizing, I believe, what Her Honor has already emphasized, is that the Code of Regulations permits arguments that are based on the existing record and shall not exceed the scope of the record of duly admitted evidence. And that's in this administrative case, in the hearing below. Administrative evidence that was in front of the judge. Everything that the defense attorney said today is not evidence, and it's beyond the scope. The board is asked by the defense to ignore the law and consider evidence outside the record. Respondent's defense brief, I'll point out, is filled with evidence and references outside of the record of this case. Now, the board cannot legally consider this evidence in reconsidering discipline today, nor should it even want to. The defense argument and what it attempts to declare as relevant does not bear on what happened in this case, specifically with Dr. Smith's care of these two patients. In fact, the brief includes references to articles that were not even a part of the evidence at the case and do not bear on the disciplinary considerations. Specifically, I just heard defense counsel bring up that with regards to the use of MMEs or morphine equivalence dosing, which was an issue at trial, you heard a lot of testimony from the defense attorney just now as to opinions and what is he referred to in the brief as the in vogue thing at the time as to enforcement of MMEs. That issue was litigated in front of the court. That issue was ruled on by the court. The judge found substantial evidence to discipline Dr. Smith for his care of patient B specifically. This board sustained those findings. And significantly, the LA Superior Court found that there was substantial evidence to sustain those findings. And again, to emphasize that point, the court found in the Rick case substantial evidence as to both patients, patient B and patient E. The court expressly stated that its decision regarding the other three patients, A, C, and D, did not affect B and E, did not affect the fact that there were serious violations in this case, according to that court, did not affect that court found no manifest abuse of discretion by this board's imposition of discipline as to those two patients. What counsel attempts today, with references to street limits and other hyperbole, is to make Dr. Smith appear as the victim here, as if he didn't have a chance to put on a case when this case was tried. He did. He had plenty of opportunity. As the Superior Court made very clear when it found that substantial evidence existed in the record, the judge points out specifically that Dr. Pope, the medical board's expert, was subject to direct cross-examination, redirect, recross for several days, and did not find any issues with the credibility or the evidence that was in the medical board's complainant's case. In addition, Dr. Smith was also subjected to several days of direct and cross-examination, and he testified as a percipient expert witness. Now, counsel attempts to compare, I guess, the experience and the credibility of the two witnesses. And as the court is aware, the ALJ found Dr. Pope to be more credible, but counsel points out that Dr. Smith has been practicing for decades. What the court found is that Dr. Smith was completely unaware of the changes in the standard of care. So the fact that he's practicing wrong for decades, that doesn't mean anything in terms of public protection. That doesn't make him more credible than Dr. Pope simply because he's been doing it wrong. He should not somehow be given a pass. The evidence was clear. They brought in their own patient. They had plenty of opportunity to demonstrate through Dr. Smith his explanation of his care. And the board agreed with the Superior Court or with the administrative law judges that there was enough evidence to sustain the findings. There is no need to relitigate this case. The suggestion that it is somehow unfair because the record is infected, that it's impossible for this board to decide what the appropriate discipline would be for patients B&E, that's far-fetched. There is nothing suggested by the Superior Court that the record was infected. In fact, a close reading of the court's order actually shows that there was only a handful of statements that colorably satisfied the statute, and therefore the experts should have been permitted to testify as to a handful of statements. It is far-fetched and it is a reach for this board to believe the defense argument that the record was infected. That is not the case, and don't be fooled by that argument. The board can and should be able to make a careful reconsideration of the evidence before it for patients B&E and reach a fair determination as to what probation should be in this case. One other thing about an attempt to, I guess, rehabilitate Dr. Smith with evidence outside the record, as you just heard in some of the comments by Mr. Riffett, is that he was not a vigilant physician. The ALJ found that he was not vigilant in monitoring the care of either patient B or E. See the decision. Don't take my word for it. Don't take Mr. Riffett's word for it. You can read the decision. You can see the transcripts while you are reconsidering this case, and you can see in black and white that the court found, the judge found that he was not vigilant, and there were serious departures involving his monitoring of one of the patients B's use of opioids, testing positive for cocaine, not following up on that. Very, very serious, for which we only have had, if this board does not reimpose discipline, 20 months of probation monitoring. Only 20 months. The next lowest form of discipline would be a public reprimand. And for the charges involved in this case, that would be outrageous to consider. He needs to be put back on probation. I have recommended in detail the probation recommended by complainant's counsel, but I'd like to just finish clearly with, if there's any suggestion that Dr. Smith is being victimized here by an excessive penalty, I'd like to remind the board that he did not receive the full weight of the disciplinary penalty that he could have based on the charges in front of the board for this underlying case. Now, as to just the excessive prescribing penalty alone, minimum penalty is 5 years, the maximum is revocation. He wasn't revoked. He got 7 years probation. It also included a included a suspension of 60 days or more. He was not suspended. It included a surrender of the DEA permit. That's one of the applicable terms that can be imposed, but it wasn't imposed. A total DEA restriction for his entire term of probation, that was not imposed. He had a partial restriction of his DEA license which temporarily restricted him from prescribing Schedule 2, 3, and 4 drugs, but it permitted him to continue prescribing Schedule 5 drugs and other prescription medications. And this this restriction was lifted after he completed an approved clinical competence assessment program. All the other standard terms and conditions were imposed. With regards to the gross negligence charges, again, maximum penalty could have been revocation, and that was not imposed. Solo practice prohibition, which could have been imposed in this case and would have fit the facts of this case, that was not imposed. There was a prohibited practice restriction, but that was lifted, which prevented him from performing intrathecal care with his patients. But that restriction was lifted after he successfully completed a clinical competence assessment program. So there are significant terms that he could have been hit with that he was not. Again, the decision was carefully tailored to address his deficiencies. And as we stand today, we've had 20 months of probation monitoring in an extremely serious case, just looking at patients B&E alone. And
1 minute.
The board should, again, and I've outlined this in my brief, but the board should reimpose discipline of 5 years, reimpose all of the same terms and conditions, with the exception of the condition for patient notification under Business and Professions Code 2228.1, as that the purpose of that statute does not apply to the allegations for B&E. It is requested that this be issued non-protonc to the original effective date, which is in October of 2020, which would place a termination date of probation in October of 2025. And it's complainant's belief that that would serve public protection and patient safety and adequately cover any sort of practice deficiencies that exist and continue to exist in this physician's practice that the board does need to be mindful of. Thank you.
All right, closing remarks, 5 minutes. Mr. Riffett, please let me know when you are ready.
Thank you very much, Your Honor. And I do want to inquire, if I may, just as a point of order, did you want Dr. Smith to have an opportunity, or rather, is there an opportunity for him to speak outside of the 5-minute rebuttal?
Yes, I will swear him in after the 5-minute closing.
I do appreciate that, Your Honor. Thank you so much. And I'll begin, if I may.
You may begin.
So the members of the board, I think what Mr. McKenna has ably argued and ably illustrated for us is that if we evaluate David James Smith, MD, today, July 22, 2022, we have good reason to believe, based upon the record and based upon what Mr. McKenna has said, that he is competent to practice and does not pose a risk to patients. There were 2 items that Mr. McKenna identified that I think are pretty telling. One, Dr. Smith, a pain management physician, had his ability to prescribe completely impaired and suspended pending an evaluation of his competency based upon the prior discipline that this board imposed. That restriction was lifted following a competency assessment. In other words, this board has already concluded that Dr. Smith is competent to provide care to his patients relative to controlled substances that form the lifeblood, if you will, to use a very poor term, of pain management. And then secondarily, Mr. McKenna pointed out that this board previously imposed discipline that restricted Dr. Smith's ability to provide any care related to intrathecal delivery of pain medication. And just briefly, I know this is in the record, but intrathecal treatment is a modality within pain management that allows for the infusion of medications, pain medications, directly to the patient's central nervous system to mitigate their pain. That's a lawyer speaking, not a physician, but that's my thumbnail of it. This board concluded that Dr. Smith was competent to provide intrathecal care, which is the care that in part was at issue for the 2 patients we have today. So as we evaluate Dr. Smith based upon the record as it stands on July 22nd, 2022, both relative to his ability to prescribe controlled substances for the control of pain and his use of the intrathecal modalities, this board has concluded that he is competent to practice. And so any imposition of discipline today would serve only to punish him for conduct that is years old, as opposed to doing what the board is statutorily charged to do, which is to ensure that the public is protected and that the providers who are licensed by it are competent to render care. And I should note that it's important to note that what's absent from the record is an interim suspension order for some sort of potential issue that Dr. Smith exhibited during the course of his thus far probation during the last 20 months. Mr. McKenna, I think, was imprecise in what he told you about the discipline. Dr. Smith's license was revoked, but that revocation was stayed. If there had been any issue with Dr. Smith's practice, this board, I think, would have been properly able to consider an interim suspension order, but there hasn't been any. And I would suggest to you, just as you can look to the evidence that exists in the record below, you also must consider the record that does not exist. So substantial evidence missing from the record that would be subject to review if this panel decides against Dr. Smith is the absence of any indication that Dr. Smith poses a risk to patients, is the absence of any indication that Dr. Smith has breached or departed from the standard of care over the course of his probation. There is no evidence concerning his competency or not as we sit here today, other than the fact that he hasn't the restrictions that were imposed upon him were lifted. And there is no expert testimony available from Dr. Smith through his expert concerning his overall competency. I'll note a couple last issues. One is,
1 minute.
Thank you, Your Honor. Mr. McKenna said that Dr. Smith was not aware of a change in the standard of care. Well, I would commit to you the legislature's findings in Business and Professions Code section 2234, in which the legislature itself said that it takes up to 17 years for changes in the standard of care to be absorbed by practitioners. And then lastly, a technical issue is Mr. McKenna wants you to enter an order nunc pro tunc. That is a wonderful lawyerly Latin phrase. I would suggest to you, and you can obviously seek counsel internally, a nunc pro tunc order in this case would be procedurally inappropriate and would be subject to being set aside yet again by the Superior Court in Los Angeles. And with that, I submit, and I thank you very much, doctors and public members and Your Honor.
All right, thank you. All right, Mr. McKenna, you have 5 minutes for a closing argument. Please let me know when you're ready.
I'm ready, Judge.
All right, you may begin.
Thank you, board members, for your attention this morning. To begin with, there is nothing subject to being set aside because of the board issuing an order nunc pro tunc to an effective date 5 years from the initial decision. I made clear in the brief that I submitted that the board should not impose a probation term longer, should not extend the probation term initially given in this case, and based singularly looking at the conduct in patient's B&E, that 5 years would have been appropriate. And it would have been appropriate to also include when he was placed on probation and was dutifully following probation, as we can only assume. And in terms of this somehow impacting his ability to come in and petition for early termination of probation, that is a red herring. There is nothing that would prevent him from petitioning this board for early termination following an order today or in the near future that places him back on probation, consistent with our recommendations of 5 years. He is free to do that and exercise his legal right. There's nothing about that that is prevented. But I want to get back to, I guess, my opening comments, which are well-founded, is that the defense wants to lead this board into error and consider evidence outside the record. Again, I'll commend you to the brief, and you can see it. It's plain as day in several areas that there is an attempt to muddy the waters and get the board caught up in things that were not in front of the judge. That wasn't the case. This wasn't sworn testimony. This wasn't duly admitted evidence. This is just smoke and mirrors. And that should not mislead this board. And what its job is to focus on patients' B&E and come up with a probation decision and order that will protect the public, which is the mandate that this board is sworn to follow and should follow and does follow. Another interesting thing was that it was represented that this board has determined that he is competent to practice medicine. I'm again referring to outside evidence, not in front of this board, but again, another muddying the waters, because this board has made no such determination. He has actually not fulfilled the probation term that he originally was put on. So certainly there can be no determination that he has been declared competent to practice. And somebody with years and years of poor practice, as found by the judge in the underlying matter, it would take at least a few years. 5 years would be the perfect number to watch him. Not a month, not 2 months, not 20 months, but 5 years to watch this physician and determine if he is safe to practice. Again, it's relative to the seriousness of the violations involved. And that does not need to be relitigated. It's just misleading arguments, ladies and gentlemen. And I would want to also point out to you, if you, just in the brief in and of itself, there's bold misstatements that attempt to mislead this board. And I would like to just point your attention to this. And if you're taking notes, you can write page 3, and this is in the petitioner's brief, or Dr. Smith's brief. And they write that Dr. Smith argued, and the Superior Court agreed, the decision erred in the wholesale exclusion of Dr. Smith's expert witness.
1 minute.
Thank you. The decision was unsupported by the evidence, and the discipline it imposed was excessive. Only one out of those 3 statements is true, and that's that the wholesale exclusion of the expert was found to be legal error by the court. The court did not agree that discipline was excessive. The court did not agree that the evidence was unsupported. On the contrary, when you look at the court's order, it expressly states the discipline was proper. In the court's own words, the serious nature of the violations. The court even states, as far as the evidence being supported, it says the penalty imposed, or I beg your pardon, the weight of the evidence supports respondents' findings on this record. So there's been a lot of misleading evidence, statements, either in oral argument today or in the brief submitted to you, that I would be mindful of. And again, just want to reemphasize.
Time.
Thank you.
Thank you. All right, Mr. Rivett, do you wish to have Dr. Smith provide a statement to the board members with regards to the appropriate level of discipline as it relates to patients B and E?
If he pleases, Your Honor, yes.
All right, Dr. Smith, the first thing I need to do is swear you in. Please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Please state and spell your name.
David James Smith, David James Smith.
Right.
Excuse me, Your Honor.
Yes.
This is the court reporter. Thank you. I'm not hearing the witness very, he's pretty faint, Your Honor. Hard to hear him. Thank you.
All right, if you could keep your voice up, get as close as you can to the microphone and speak slowly, that will help our court reporter.
Of course, and just tell me if there's still problems.
That sounds better to me, Ms. Temple.
Yes, Your Honor. Thank you. It's good.
Thank you. Thank you, Dr. Smith. You may begin.
Good morning, ladies and gentlemen of the board, Your Honor. I appreciate you taking time to have me speak a little bit. I come to you today very contrite and humble. I'm not here to talk as an attorney, but as a physician who's practiced now for 30 years and taken care of tens of thousands of patients over 30 years of practice in San Diego County. I do want to clarify a couple of things that Mr. McKenna did say that I want to make sure that the board hears from me directly. I do not consider myself a victim in this matter. I understand the discipline that was imposed. I do think that it was very difficult for me to to present my case cleanly without having the benefit of my expert witness during the proceedings 2 years ago. I thought that that was unilaterally unfair towards me, but that's the way it went, and that's the deck of cards I was handed. And so I have done everything that was imposed upon me, and I've done so timely and in good faith. I haven't complained. I do want to make one other correction to Mr. McKenna's comments, though. My discipline, even though the judge set aside the order, my probation officer, Virginia Addis, has made it clear that as far as she's concerned and the people in Sacramento are concerned, nothing has changed. So I have still complied.
So Dr. Smith, I just want to remind you that you cannot provide information to the panel members outside the scope of the record that's before them, and that was related to the underlying case. I know there's been some oral argument about that, but you need to limit your statement to the board with regards to the appropriate level of discipline as it relates to patients B and E, and not bring up things that are not before them in the record. Do you understand?
I do, but it does pertain to the discipline because I'm still following the terms of the discipline. I haven't stopped. That's my point. I'm still proceeding with my monitoring with Ms. Addis. And so it did not stop in January or February or March. It's still proceeding. I continue to participate under the terms of the probation put forth by the administrative law judge in 2020. That's my point, to show that I am serious about the disciplinary order put upon me. So I thought that would be important for everybody to understand. I'm a good doctor. I've worked very hard to take care of my patients. I don't have much to say except that I'm more than happy to do whatever the board recommends I do. I have been compliant, will continue to be compliant. I did fly all the way out to Texas to do the K-STAR program because PACE could not take me in San Diego.
So Dr. Smith, that's not before the board. So I'm just going to ask you to, again, remember, please limit your statements to the board with the evidence that's before them related to that underlying accusation. So the issues with regards to that are before the board right now at this time.
So do you want me to discuss just patients B and E then?
As it relates to any statements you have to the board with regards to what you believe the appropriate level of discipline is as to those patients and the conduct that was found by the administrative law judge and upheld by the Superior Court.
Okay, well, I appreciate that. And just correct me if I go off narrative again. I don't know if the board is aware, but patient E was referred to me by another pain management physician because of high opioid use in San Diego County. And the record shows that the first thing I did on that patient was drop the patient's opioids by 33% and then quickly move forward to try and use interventional techniques to further wean the patient E off the opioid. So that hopefully is something that's pertinent and can be considered by the board. As far as patient B is concerned, I discharged patient B because of noncompliance and also attempted to get him into a rehab program, but he was denied access to the rehab program. So I just asked the board to look closely at the records for patient B and E because there are some circumstances that I believe would temper the 7-year disciplinary action put forth by the judge. I think that my discipline to date has been 20 months so far, and I feel that's an adequate amount of discipline given my compliance and the changes that I've had in my medical practice. But if the board feels that additional discipline is warranted, I'm certainly will comply. I'm here to be compliant and to participate in any way in my rehabilitation.
All right, Dr. Smith, I'm going to ask the board members if they have any questions, starting with our chair, Dr. Thorpe. Any questions?
Yes, I do. I have a couple of questions for Mr. McKenna and for the Respondents Council as well, Mr. Rafat. And if I could maybe start with, is it appropriate for me to ask a question of Dr. Smith?
You can ask the question and then I'll wait to hear it.
Okay, all right. So this is related to patient B,
Yes.
and it's related to a couple of to the administrative law judge record of where the original discipline was that was decided on. Number one, and this is related to the roxicodone addition. It appeared that he was getting 45 morphine equivalents for a period of time with 10 milligrams of Valium a day, and then he was increased to 75 morphine equivalents in the form of oxycodone.
I'm sorry, excuse me, the reporter. I lost you. He was increased to, thank you.
So he was increased to 75 morphine equivalents several months later. I don't have it right before me, but it was a period of 6 to 8 months later. He was increased to 75 morphine equivalents, and then about 4 months later, the addition of roxicodone, 40 milligrams, 140 tablets over 14 days. And it wasn't clear to me, number one, was that 14 days, was he repeatedly getting that every 14 days? So he's getting 450 morphine equivalents every day, in addition to other short-acting medications? Or was I'm not clear from the record how that was managed, and it would help me if I could understand. It appeared to me from the record that roxicodone was not given every 2 weeks, every 14 days, but it was given periodically, but that wasn't provided in the record. And I'm just asking Dr. Smith if he could help me understand that.
So I just want to make it clear, if it's not in the record, he can't answer. If it's in the record, but it's unclear in the record, then if there's clarification that's in the record that Dr. Smith can direct you to, then I can allow that. It just can't elicit new evidence.
Yeah, no,
this presented.
Yeah, this is definitely in the record.
Okay.
I can give you the page number on the administrative law judge. I didn't have it up here. Just a second.
All right. So Dr. Smith, do you understand the question?
I do, but I have not seen the record for several years now. I'm at quite a disadvantage.
Do you have the record before you?
I do not, Your Honor.
Okay.
Well, yeah, I'm sorry. I apologize but it does. So this is getting to the issue, in my view, as an internal medicine doctor who has done some pain management over the years. It's getting to the issue of the question of being careful or not in your management of prescribing chronic opioid narcotics. And to me, that question was unclear. The reason I say that, especially when we're only looking at patient B and E, the pattern of prescribing seemed very appropriate to me for quite a period of time, and then there was this jump from 75 morphine equivalents to what was stated in the record to be 450 morphine equivalents per day, and yet when I looked at the record, it didn't appear to me that was exactly what was happening. It appeared that he was giving 140 roxicodone. Let's see, where am I? This is page, for everybody else's this is page, sorry. And this is and I guess the issue of this, my concern about this, is in response to the question of what discipline and what's the appropriate action of the medical board today. I'm sorry, in patient B now, and now I'm here. Okay, so this is on page 62 of the administrative law judge record. And it states, over the course of the treatment, respondents' opioid prescribing increased. Dr. Pope explained tolerance occurs, etc. During the relevant period, the opioid doses on the cures report, August 14 through August 14, 2013, reflected the following: March 14, Norco, 45 morphine equivalents; May 16, 2013, oxycodone. And in actuality, he'd been getting the Norco for a period of time before that, even in 2012, but it was stepped up in May of 2013 to oxycodone. At that time, he was getting 75 morphine equivalents through July. And then in August, he was given roxycodone, 30 milligrams, number 140, for a 14-day supply. But it wasn't clear to me if that was renewed every 14 days or if that was given, 140 tablets for a period of time for him to use as needed for breakthrough pain or for whatever. It just wasn't clear to me.
Dr. Smith, can you answer the question if you know?
I do. That was at the end of his treatment, and we were discharging him and trying to get him into rehab. And so my understanding, the best of my understanding, is that prescription was given so he would have time to get into the rehab treatment since he was being discharged from my practice.
Okay. Thank you very much for that clarification. So the other question I have for the respondents council is this. It does concern me that you've kind of, in a way, you've kind of asked for us for you how to have your cake and eat it too. On the one hand, you say that we should just not do anything more, and yet because of the difficulty with the respondents' lack of an expert witness, and yet you also say we shouldn't retry the case completely with having a chance to get a second shot at this and get it right. Can you speak to that?
Yes, and Dr. Thorpe, I appreciate the question. I think it's an important one, and I agree with you. I agree that the notion, hey, let's not do anything today, is not entirely satisfactory. I mean, obviously, from my standpoint and my client's standpoint, it'd be wonderful to say, look, bygones are bygones, and we're done here. And on the opposite end of the spectrum, it would be difficult and costly and, frankly, to use a lay term, stupid to retry this case. So what is the alternative? I would suggest to you that a palatable alternative, given the 20 months of probation that Dr. Smith has been on, is to continue another year of probation. I think that would provide enough confidence that the board would have to evaluate his care and whether he's adapted. So an additional year, and then not do anything to disrupt his ability to petition for early termination based upon the date of the original decision. I realize that's a complicated way of putting it, but the idea would be Dr. Smith is entitled to petition for reconsideration 2 years after the imposition of his discipline. I wouldn't want to disrupt that. And there is a safeguard in allowing him to do that, even though that is earlier than perhaps what might otherwise occur, which is in his petition, he must establish his competency and his ability to resume practice without restriction. So I think and honestly, as an accommodation, I think a year additional, or a year from today, excuse me, would be appropriate. Dr. Smith is, and I don't have guess here, but Dr. Smith is near retirement age, although he looks younger than I do. So I think the 5 years that Mr. McKenna is proposing is punitive. And I think, Dr. Thorpe, you're right in pointing out that this really at a pragmatic level shouldn't be a zero-sum game. And I do think that allowing him to petition on the current schedule for lifting of discipline and otherwise extending his period of probation from today by a year would be reasonable.
Thank you, Mr. Rifa. And then, Mr. McKenna, I have a real concern, I guess, and that is Number one, I found a number of errors in this record that were, I believe, just blatant errors. I mean, for instance, Norco, I think it's page 42. There's a script relating to Norco, and it refers to it as hydromorphone, which is totally erroneous. Norco is hydrocodone, which is 1-to-1 morphine equivalent, and hydromorphone is 4-to-1 morphine equivalent. So it's in error in that case, and it appears to me that the case, especially in patient B, was made to look as if Dr. Smith was prescribing quite large amounts in terms of morphine equivalent doses. Now, not to excuse the issues with monitoring and the issues with lack of compliance to his to illicit drugs and those kind of things. But it troubles me that our cases are being built on this house of cards in a way. But my question really is this. I guess that's a statement, but my question is, the discipline that was imposed by this panel back in January of 2020 or whenever it was based on the totality of those 5 cases. It was based on patient A, patient C, and D, and B and E. It wasn't just on B and E. And the reason that those, in my case personally, as I looked at this case, the reason that the severity of discipline was given was because of those other cases. Not, if we would have taken B and E by themselves, I don't believe, well, it just seems inappropriate to me. I'm asking you, given the fact that discipline was for the entire 5 cases and not for those 2 cases, does not it seem reasonable to decrease the discipline somewhat in your opinion? You're on mute, Mr. McKenna.
Mr. McKenna, you're muted.
Okay, I beg your pardon. Thank you, Your Honor. Thank you for the question, Dr. Thorpe. Well, we have in our recommendation as complainant decreased the probation. I agree with you. There's no other reasonable way to look at it that the penalty imposed was based on all 5 patients. And now we are looking at the 2 patients. And I'd have to respectfully disagree as far as the type of patients, cases that we get that come through the pipeline that we litigate year in, year out. The departures with patient B alone and the finding of the violations routinely get 5 years, routinely get probation terms that include practice monitoring, oftentimes will include a DEA restriction for a period of time or for the entire time.
So, Mr. McKenna, I just want to remind you, please focus on what's before the board. I understand that you're trying to give some examples, but I think I'm also concerned that it's going beyond the scope of the record that's before the board. So it needs to be limited to that, please.
Will do, Judge. I guess Dr. Thorpe, with your concerns, I can only direct you to the record beyond the judge's order. In your careful consideration of this case, pull up the transcripts. And you'll have to look at the transcripts and for the day of testimony, and you can find the testimony regarding patient B. I can't speak to this, this particular typo in the court's order, or the court's proposed decision, but look at the discussion, look at the heavy vetting of testimony by Dr. Pope. Again, several days of examination, and much of it would have been about patient B. And look at the testimony of Dr. Smith in real time about patient B, who would have had the medical records in front of him. That's the best example to answer the questions that you have and your concerns, and whether or not you should impose discipline in this case of what I've requested, 5 years, which Again, referring to the medical board's disciplinary guidelines, which are part of the record. The outline of this case, the profile of this case of patient's B&E, it is our recommendation that I've already made in the brief. I won't go into it again, but that it's consistent with the violations. And it's also not just the excessive prescribing of opioids, but there are also multiple departures of gross negligence that were very serious, as found by the board's expert, which regard his prescribing despite positive cocaine tests, which is in the record, ignoring other information that he would have learned while seeing the patient, following drug screens. Again, he's not carefully monitoring the patient, contrary to what you heard earlier today, and just conflicting information in the medical record about a patient whom he's prescribing a whole host of complicated polypharmacy. You've got opioids, you've got benzodiazepines, you've got muscle relaxants, antidepressants, all sorts of drugs that patient B was taking. So, I just don't have a great answer for you, Judge or Dr. Thorpe, because I can't testify here. I just would direct you to the record, direct you to the days where he's testifying and the expert is being examined. And I hope you can find an answer that, satisfies you.
Anything further, Dr. Thorpe? You're muted, Dr. Thorpe.
Thank you, Your Honor. That's all I have.
All right. Dr. Heltzer, any questions from you?
Thank you, Your Honor. I have a question for Mr. Riffett. Mr. Riffett, in Mr. McKenna's closing statement, he referred to an assertion you made in your brief that the Superior Court agreed that the decision was unsupported by the evidence and the discipline imposed was excessive. Could you respond to that?
Yes, of course. And I will take some responsibility for being imprecise. Relative to all of the patients except for those two that were left, the court's conclusion was that Dr. Smith had been denied fundamental due process, and consequently, those statements are true relative to the three patients that were cause for the decision being set aside. Thank you for the opportunity to address that.
Thank you. I don't have any other questions, Your Honor.
Mr. Brooks, any questions?
I don't have any questions, Your Honor. Thank you.
And then Ms. Lawson, any questions? No questions?
No, thank you.
All right, anything further from our board members? No? All right, then with that, if there are no additional questions, then this concludes the arguments in this matter. The record is closed, the case is submitted, and we are off the record.
Thank you very much, and thank you, counsel.
The panel will be deliberating in closed session, so I'm going to turn this back to our chair.
Thank you, Your Honor. Just to remind the panel that we'll need to exit this this application and re-enter under the closed session application. So we'll close this out now and re-adjourn. Do we need to ask for adjournment, Carrie?
No, because I believe we will come back to open session to close out.
I will hold this meeting open for you, Dr. Thorpe, and you'll have to come back here and adjourn when the deliberations are completed.
Oh, that's right, Jen. Okay.
Excuse me, this is the court reporter. I'm sorry to interrupt, but do you need me to stay or should I go now? Thank you.
You don't go with us into closed session, but I do have to get some information from you about today's hearing.
Yes.
So I'll just get that from you and then you will be free to go.
Okay, thank you, Your Honor.
All right, so I see I have your name and your CSR number. I just need an end time and a page count. Ms. Temple.
I'm sorry, I was on mute. Thank you.
Okay.
Page count is 50, and the end time is 12:13. Thank you.
Wonderful. Thank you so much, Ms. Temple.
Thank you, Your Honor.
Welcome back, Dr. Thorpe. I already took down the closed session banner, so you guys are.
Okay, thanks, Sean. So I'll call the open session back to order for the purpose of adjournment. Is there a motion for adjournment?
So moved.
Thanks, Dr. Helzer. Hope you have a great weekend. The meeting is
well.
adjourned.
Thank you.
Okay, bye.